Catherine, Migori. Catherine, Migori.
La moja ya sentence. Kuna sentence
So no, it's not being fair.
Was I supposed to serve with the reply before serving the notification?
Are you kidding? How long have you taken to serve upon reading mine?
5 minutes.
Yeah, the same thing, by the way, even as we've just filed it.
Really?
Yeah, we just filed it. I'll give it back. Just let me read it.
That's the copy.
Give the copy.
It's the one that it's the one that she's reading.
We don't have to listen. And remember, there are three. He's saying one, there are three. Officers, but they are not, those are not the ones that were recovered, not for the police officers.
What you're saying is as well as our ground transport. And I attacked
This is number 14. 14 is contradictory.
Police officers,
one of them told them that this is one recovered. You see, it's even contradicting and told them that no phone was found within my house. He's coming to talk about
which is also
Correct. I'm like Billy to 2 minutes.
He's the one for Kimaro. This one I can knock down. There's another case from Kenya. It has been overruled from Kenya's case. Can I forget that case? Even meeting them happy they brought in
excuse me. Yes, are you done?
Give me 5 minutes now. Give me 5 minutes. Huh?
Nipatie kopi ya sababu hiyo ya authorities.
Papa, wait first. Let's first finish, then you put, Roger. No, last time we could be hard. We could be hard whispering. I hope these ones are off, Huh? Nai? Is this one off?
Just put them aside.
Yeah, you'll put aside when she... Yes, my lady, I believe we are ready. We have filed our notice of motion dated today, the 15th of November 2018, together with our supporting affidavit by one Inspector Philip Sang, sworn today, the 15th of November 2018. Your Honor, we are here pursuant to Article 49, 1F, and Article 49, Subarticle 1H, and also pursuant to Section 36A of the Criminal Procedure Code. Your Honor, I am relying on the affidavit of the said Inspector Philip Sang, praying for continuous detention of the respondent for a further 15 days. Your Honor, the respondent was arrested or placed into the custody of the Special Crime Prevention Unit on the 14th of November 2018. He has been produced before court within 24 hours. And therefore, we have complied with Article 49, Subarticle 1H, which provides that an accused person must be presented before court within 24 hours. And if presented before court, to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. Your Honor, this application, as again I've stated, is supported by the affidavit. Your Honor, the affidavit prays for more time, as upon search being conducted the respondent's rural home, several weapons, that's 3 firearms and ammunitions, were recovered. Then upon the respondent being questioned on the status of the weapons, he did not give any satisfactory account of how he came into possession of the said firearms and ammunitions. Your Honor, the respondent is suspected to have been in possession of the firearms without a valid certificate, contrary to Section 4.1 as read with Section 4.2a and 4.3a of the Firearms Act. And also for being in possession of ammunitions without a valid certificate, contrary to Section 4.1, again as read with Section 4.2a and 4.3a of the Firearms Act. Your Honor, this affidavit clearly informs the respondent of the probable charges, the nature of investigations, and if investigations are carried to conclusion, this would be one of the most probable charges. Therefore, the reason as to why he's been arrested has been disclosed. And the investigations have also been disclosed. Your Honor, the reason why we're asking for the 15 days is to allow the investigating officers to travel back to the rural home to conduct further and thorough investigations, scenes of crime officers, and other relevant officers, including ballistics, will have to go to his home to investigate and thoroughly analyze the homestead. Your Honor will also need the said time to check whether the said firearms have been involved in any other crime, any found in the affirmative, other probable charges may be placed, or the investigating officers may confirm the same. We need the said time to check through the firearms data who the real licensed firearms are. We also need the said time to go through the mobile data of the respondent and other probable suspects. We also need the said time to confirm whether there are other probable suspects. We need the said time to record statements of other vital witnesses whose names we cannot disclose at this point so as not to jeopardize the investigations or to disclose their identity. Your Honor, we praying that the continued detention orders be given so that the respondent may not interfere with the ongoing investigations, may not interfere with the probable witnesses. And my lady, it is in the public interest that we are asking for this time to conclude our investigations. Your Honor, noting and interfere with in the investigations. And it is in the public interest, Your Honor. We are praying to be given ample time to conclude the investigations. Your Honor, even just to rule out the fact that these firearms could have been used in any other crime. And para 4 of our affidavit has indicated the 3 firearms that were recovered. The types of firearms that were recovered, Your Honor. It is important that we investigate thoroughly why the respondent could have been having 3 firearms and ammunitions having not been licensed. Your Honor, I haven't had an opportunity to look at his replying affidavit,
He has confirmed in paragraph 14 of his affidavit that he was informed by his bodyguard that 2 guns, as he has described as Seska pistols, were found in a metal suitcase during the search in the presence of another bodyguard. So he's confirming that these firearms were recovered in his homestead. Your Honor, this contradicts paragraph 12 of his affidavit when he states that no firearm was found within his house in Rapogi, and that he has 1 firearm and he has no reason to apply for further firearms within his license. So he's confirming that there's 100% probability or possibility that these other firearms that were recovered in his home did not belong to him. Your Honor, that is why it is important for us to investigate the same. And we believe the 15 days, Your Honor, will not prejudice him, because I believe it will also be in his own interest that he would want this matter resolved. Your Honor, further, on going through the 2 authorities availed by the respondent, that is in their applicant's list of authorities, number 1 and 2. Your Honor, the second authority, that is Wais Abdulaziz Muhammad, clearly distinguishes the matter before you and the matter that was before in the first authority, that is miscellaneous criminal application number 304 of 2016, Michael Rotich. So Waziz supports us. Michael Rotich is distinguished from our case and from the second authority. My lord, in Michael Rotich's case, the main contention, among others, was that he was never informed of the charges that he was likely to face since his arrest. In our case, under para 7 of our affidavit, we have indicated that the most probable offense would be that of firearms without a valid certificate and possession of ammunition. This is, Your Honor, at this stage, and that is why we are praying for the ample time to rule out whether there is any other offense that could have been committed. If the court gives us ample time, especially to confirm if the said firearms had been involved in any other offense. And Your Honor, this is very important even for the public, noting that maybe there could be unresolved cases and family members would have wanted conclusion in those unresolved cases. In the second authority, that's the Abdulaziz Muhammad, that is in their second authority, Lady Justice Ngenye correctly found that under Article 49, 1G, the Wise case, on page 5, correctly found, that is on paragraph 1, from line 6, correctly found that Article 49(1) allows the detention of an arrested person without trial. 49(1), subarticle 1, subarticle G, allows the detention of an arrested person without trial, as long as he is informed of the reason of his continued detention, and that the continued detention, Your Honor, this is important, is made with the leave of the court. And she correctly found that there was nothing unconstitutional or illegal in the order made for the detention of the applicant without a charge. Your Honor, and that is why we are before you under our notice of motion to pray for the continued detention and to seek leave of this honorable court. We are therefore praying, Your Honor, that this court finds that there are compelling reasons to warrant a denial of bail pursuant to Article 49 and thereafter does order that the respondent be detained for a period of 15 days, as held again by the Waisis Abdulazi case on page 8 and 9. Now we respectively pray that this honorable court does confirm the notice of motion and does grant us the orders prayed in our notice of motion. That is all.
Your Honor, Sagana for the response. Allah. Respond alongside with my colleague Mr. Mbeta begin. The application is proposed. We have filed a replying affidavit dated and filed today, 15th of November, by the respondent. And we have also filed a list of authorities with 3 authorities. Now we want to emphasize and show court the levels of malice and bad faith of the police and the prosecution in the application before you. I'll start with paragraph 7 and 8 and bad faith. Exhibited by the prosecution and the investigating authorities. Your Honor, in paragraph 7 and 8 of the affidavit, the respondents depends on its common ground that while the search was conducted, he was in his house in Lavington in Nairobi and not in Rapogi, Uriri in Migori County. He admits that he had a licensed firearm with him alongside those of his bodyguards, which firearms were verified and all returned to him. To him and his bodyguards. Those firearms are not subject of the dispute now before you. My colleague, Ms. Monique, who I have tremendous respect for, has voluntarily chose to read half of paragraphs 12 through to 14. I'll help her in the other half. In paragraph 12, he deposed that there was no firearm found in his house in Rapogi, none whatsoever. And in paragraph 14, he deposed that 2 firearms, this is information he gets from his bodyguard, 2 firearms were found in a metal suitcase inside the guardhouse. And he also deposed that a 3rd one was brandished by an accompanied officer who was doing the search and accompanied also in the guardhouse. So it's malicious not to read this part when it's common ground that those 3 were found in the house for his guards. He also has deponed in paragraph 17 that guardhouse is in the exclusive possession, operation and management of the security details provided to him by the Kenya National Police. Your Honor, it's also important to mention paragraph 16 that the last time he stepped in his home in Rapogi was on the 2nd of September 2018. That's almost 3 months now. And one of the bail terms in the case he's facing, criminal case number 46 of 2018, bars him from going to his home. That is deponed in paragraph 16. The bail time bars him from going to his home, and he's never been there in compliance with the bail term. So that any allegation by the prosecution that they would need to visit that home for purposes of conducting investigation, and they are apprehensive that he may interfere, is completely misplaced. In paragraph 20 and 21, he deposed that he's done everything necessary on his part to help with the investigation of this matter. He's recorded his statement. He's done all required of him by the DCI. Late last night, they asked him to surrender his licensed firearm, which he did. He also did with the magazine and the round of ammunition together with his firearm license. All those are deponed in paragraph 20 and 21. I keenly heard my colleague, and she mentioned several arms of investigations that are still pending. We have no problem with them conducting the investigation. Not one single of them require his detention. we've made lots of gains in the new constitution, and Article 49F1 obliges the state to produce any suspect within 24 hours. So it is the state doing this and inviting this honorable court to trample on the rights of the citizen. This is punishment by public humiliation and embarrassment. I'll also invite you to paragraph 23 running to 28 on the issues of bond or bail for the bonds that is not a flight risk. 23 running to 28 is not a flight risk. It depends that you shall abide by all bail terms or bond granted by this court. He has so far cooperated with the investigation agencies and will continue doing so. Never breached any terms of bail or bond before. And demands that he shall not interfere with any witnesses in this matter or investigations in any way that are being carried out. May I also emphasize at that point that it is common ground that these witnesses have not been disclosed. So it's not possible that you'd be interfering with undisclosed witnesses. On that breath, I'll also invite you to paragraph 20, where I'll point out that the two bodyguards who were found on duty and in the guardhouse have also recorded statements with the police. They recorded statements on the 13th, unreleased, and are yet to be recorded, without any interference whatsoever. So there are absolutely no compelling reasons that have been advanced for his detention. My colleague also relies on section 36A of the CPC in our application. And I invite court to section 36 of the CPC that limits the right of liberty. Liberty is in the heart of our Constitution. Article 24, subarticle 2C, invites this court to interpret any limitation by statute. 24, subarticle 2C. Invites this court to interpret any limitation of a constitutional right by a statute to be done in a manner that enhances that fundamental right and freedom. The affidavit says that he is not given satisfactory answers. There are several charges that would be preferred. There's no reason why a charge or a holding charge has not been preferred. It's also common ground that investigations may continue after a charge. Your Honor, in my first authority, the one for Michael Rotich, if I invite quotes at page 4 to 5, it's the first authority. Page 4. Or the third paragraph. The court emphasizes that it is enjoined under Article 259 of the Constitution to interpret the Constitution that in a manner that promotes the purpose, values, and principles to enhance fundamental rights in the Bill of Rights. And this is the judicial authority that you're inviting this court. At the last paragraph, in compliance with Article 49(1)(f)(1) of the Constitution, the applicant was brought before court within 24 hours of his arrest. However, contrary to Article 49(g) of the Constitution, the applicant was neither charged nor informed of the reasons for his continued detention. As stated in the earlier ruling, the recent trend where a person is arrested and arraigned within 24 hours specifically brought the prosecution to seek extension to continue to detain such person without a charge or holding charge preferred against such person is unconstitutional. The police have no authority in law to arrest and detain a person without sufficient cause. The fourth line, very important, it will not do for the prosecution to present a person who has been arrested in court and seek his continued detention without a charge or a holding charge being lodged in court. It is unlawful for the police to seek to have a person who has been arrested to continue to remain in custody without a formal charge being laid in court. If this trend continues, it will erode all the gains made by the advancement of the human rights and fundamental freedoms as provided in the promulgated Constitution of 2010. 2 lines down continues, the police should only arrest a person when they have prima facie evidence that an offense has been disclosed which can result in a person being charged with a disclosed offense or holding charge if of the likely offense being presented in court. The police should do this only for one reason. The Constitution says so. In conclusion, the arrest and arraignment of the applicant before court without a charge being preferred against him breaches his fundamental rights of liberty and freedom as provided under 29A of the Constitution. The judge, Kimaru J., in conclusion, rules that the police shall be at liberty to charge the applicant with a disclosed offense if they have evidence. Meanwhile, the applicant shall not be arrested or detained by the police. This falls in all fours. When the investigations are complete, nothing stops them from arresting him and charging him. If you're not ready, if you have no evidence, do not charge. Do not arrest or detain. The authority of Wais Abdulaziz in page 7 and page 9, the pagination at the bottom center. At page 7, I just want to emphasize the court's decision that if the inquiries do exist, police can request for time to complete them after plea. Just emphasizing that nothing stops the police from further investigations or inquiries after a plea. In page 8, the court emphasizes that, however, I must emphasize that courts must resist to be used as a conduit to trample on suspects' constitutional rights and fundamental freedom. That is why the Bill of Rights was enshrined in our Constitution to safeguard the rights and liberty of citizens, which this court must jealously guard. My lady, I also urge you to find this authority persuasive and guard the gains made of the Constitution. And my final authority, the case of Republic versus Gladys Omboi Mwangi. It's only 2 pages. The emphases are on the second page. Lady Justice Maureen Odero relies on the decision of Michael Rotich. I've just read it. And she finds that the case before is exactly the situation that pertains that of Michael Rotich. The applicants have not been charged with any offense known in law, not even a holding charge has been preferred against them. The Kenya police must come to realization that this country is now operating under the new constitution. Liberty of all persons is sacrosanct, as provided in the Bill of Rights, Article 49. It cannot do for police to seek to detain a suspect to allow them to investigate an offense. A person cannot be denied their liberty in order to facilitate the investigation by police. Indeed, the logical thing is for the investigation to be conducted, which investigation would point to a suspect who would then be arrested and brought before court on a firm charge, or at the very least, a holding charge. My lady, this is exactly the situation before you. I urge you to find that this has been a trend ongoing. May I also mention that this morning we have been treated to a game of musical chairs. This matter was taken up to Milimani Commercial Court, and when we were filing our affidavits for very unknown reasons,
Your Honor, that's not true. That's not true. The matter was not filed in Milimani, and I need to interject and correct the status.
When we were filing ours.
Yes, but he's saying that the matter was in Milimani. That was not true. All that happened is that the respondent was placed in the cells as we were working on the document with the investigating officers in close proximity to the office, not that we were intending to register it in Milimani. That's the position.
Your Honor, before you, we urge you to find against the prosecution and uphold the constitutional gains we have made in this country. Gone are the days of detention without trial and the executive using the judiciary to trample on the rights of a citizen as and how they wish to. My colleague, Mr. Mbeta, will conclude the submissions. I humbly urge you.
You know, the prosecution brought an affidavit, and the affidavit is signed by Inspector Philip Sang. Until this particular moment, the person you have in the dock is only a respondent. He's not an accused person. There is no charge before you. So what they are telling you is that they hope or anticipate to charge him in the future, or might not charge him. But in the meantime, while this unclear situation is still there, keep him in custody. That is what they are telling you. Yana, that cannot be fair. You know, this is against Article 19 of the Constitution, totally against it, whereby it says that the fundamental rights belong to an individual and not to the state. And so what happens? Inspector Sang, without batting an eyelid, brings an affidavit in this court and asks you to hold the accused person. Without batting an eyelid, they bring the respondent to this court and ask for 15 days. Even the 24 hours that they have had until now is a stretch too far, but it is allowed by the law. But for them to ask for 15 days, Your Honor, for them to ask for 15 days, they avoid talking about Article 49H, but they talk about Article 49G. So what do? Because H says what? They must give you compelling reasons. Cleverly, they don't talk about that. Why? It's because they do not have any compelling reasons, none at all. If there is anyone today, Your Honor, please, they need to point it out, because whatever has been said is nothing. In our replying affidavit, the respondent has indicated very clearly that at the time these incidents of searches were going on in his own house in Nairobi, clearly in his own house in Nairobi, 5 firearms were found. All of them licensed, and all of them had the persons who were using them or holding onto them at that time. All of them. That was totally fair. And so they did not arrest him. Here in Nairobi, they did not even take those firearms. It only shows you again that he cooperated. This is the kind of person we are talking about. He cooperated. At the time they found those firearms, he did not interfere with those officers or do anything wrong. So when you're looking at the antecedent of a person, this is the kind of person we are talking about, Your Honor. So what do they say? That in his rural home, rural, that's the word they use in the affidavit, they found 3 other weapons. They do not tell you exactly where in that home. They do not tell you. In a home whereby he stays with extended family members. It is a home. It's a homestead. His children have houses. His brothers have houses. It's expansive. Stepmother, everybody. But what do? They come and pick on this gentleman and say, this weapon is his. That is the type of investigation we are talking about, and that's why we are saying it's malicious and it cannot be fair. In his affidavit, he says clearly, if they were found in the guardhouse in a metal box, the officers recorded statements. That is on the 13th. On the same day they were recovered, on the 13th. Your Honor, those officers are not before you today. Because why? They were never arrested. So when we want to talk about possession, then we need to be specific. Was he in possession, as they say in the affidavit? He was not. If that is not malice, Your Honor, please tell me what is. If the accused, the respondent wanted to interfere, since the 13th when these items, all these weapons were found, until the 14th when they came to arrest him, 24 hours later, did he interfere with anybody? Because they had been recovered, yes. Did he interfere with anybody? No. So when you're being told that he's going to interfere with people, Your Honor, look at it and you'll see that what they're telling you cannot be true, and therefore it cannot be compelling. Yet, when they went to arrest the accused person, he did not even try to abscond. He did not try to interfere with them. They went and picked him from where he was in a conference and went with him. You can see from the affidavit, he never in any way attempted to contact anybody or any witness or any person, and yet we do not know their names also. We do not even intend to know their names. I was present yesterday here at CID headquarters. So today they are telling you they want more time. But yesterday, they kept us from 1 p.m., at 2 p.m. They kept us from 2 p.m. at CID headquarters. The only thing they did that was good, they gave us tea. And the bread that was not even brown. They kept us until 6 p.m. when we recorded a statement. For 5 hours, Your Honor. 5 hours. What were we doing there? Yet they come to you today without batting an eyelid and they ask you for time to keep him to investigate. So when you look at that affidavit, Your Honor, and they start saying that they want the accused person, look at their paragraph number 5 of the affidavit. They tell you that they want to check the firearms data. The respondent does not work in the Firearms Bureau, he does not hold the data. So therefore, they do not need him. They want to check the system, whether the said firearms have been involved in any crime. He does not keep the system, he does not work with the system. So why do they need him again? They want to arrest crucial suspects. So he's not a police officer. He does not arrest people. Why do they need him? They want mobile data. He does not work with Safaricom, Airtel, or any other airline, data provider. Why do they need him? Because they have his number, they have his phone. They don't need him. Then they say they want to take his fingerprints, which can be done even here today, 5 minutes. Let's do it. Bring those items, we will do it. Then you have no reason to hold him. 5 minutes, we will do that. Then they want him for the recording of vital statements of vital witnesses who we do not know, who the court does not know, and who he does not even want to know. So for him, he's not even the one who, maybe they're illiterate, I don't know, but he cannot write statements for them, so they don't need him. So what are the reasons that you have been given that are compelling to do? So when I came to Article 19 saying that these are fundamental rights that belong to an individual, you can see, Your Honor, that I am actually coming from a very well-reasoned point. And therefore, Your Honor, Article 20 then involves the court, the prosecution, and the police to start by wanting to grant the fundamental rights, not by wanting to stop as they are doing today. They are not even asking you that if you release him on bond, let him be reporting. They are not saying that. They want him totally detained. Article 21 then allows you to, once you've recognized this fundamental rights, to start enforcing them. And now we are coming, even Article 22 now favors us, because we have realized they are trying to curtail our rights. If they are trying to curtail our rights, and I'm saying this is because they do not have any compelling reasons, then who do we come to, Your Honor? Who do we come to? We have suffered enough because of the bullying that has been going on with the policemen, keeping us in the police stations, giving us a lot of tea, and doing nothing about it. If they do that, Your Honor, the only person who can rescue us is you. Because if we go back to that police unit, we are just going to take tea and do nothing. Because you can see the reasons why they want him. He does not need to be present. This is a person who is a governor. And I can confidently say that today because he's not an accused person, so he still remains a governor in this court. Is this the way we treat then people? Let us go to Article 28, even by itself, whereby it talks of dignity of a person. Is this the way then we are going to treat his dignity? Is this the way we are going to handle him? Keep him in a cell for 15 days for no reason at all. This is a provision of, in the Constitution, Your Honor, and we are asking you to enforce it. Please, Your Honor. Enforce so that his dignity can be maintained. This issue of calling him every day and bullying him and going to his house at 6 in the morning when he's in pajamas, finding nothing wrong and going away and going to look for something in Migori so that they can fix him, to justify that action, those days are gone. And I'm not saying that Inspector Sang is a bad man because I know he was not there. These persons were brought to him. But I also expect that Inspector Sang should have looked deeply into these issues and seen that this was malice from the EACC officers. Kama hakuna kitu tunapata, wekelea tu yoyote tu, sukuma yeye naye atajitoa mbele. That is the story that we are having today. And you are being told now this is a matter of public interest. Public interest for a weapon that has been found in Migori. Every day there are weapons we see in the newspapers recovered anyway. Why weren't those ones public interest? Why is this one a public interest? If this is not malice, please tell me, Your Honor, what is? And then they're telling you, let us keep him in custody so that we can go and find out kama hii bunduki ilitumika mahali popote. So that now we investigate, look for an offense, then come and bring it to him. Why are we waiting for that? Let them investigate so that we can be able to come back. The accused person is on bond in a murder trial. He was given tough conditions which he has met. He has observed them. He has obeyed the rules. But you're being told he's going to interfere with witnesses. What antecedent are they going to use to show you as an example? What are they going to use? Because we are giving you a good example that he has not interfered. What do they have? Let them counter that with facts, not assumption, because they're telling you he may. So the word may only means that suspend his fundamental rights because he may. You know, it cannot work. It cannot be fair. You're being told that the ballistics officers will also require to travel to his home. Ballistic officers to go and do what? You want to see how the house was painted? Or they want to see how the roof was fixed? What do they want to see there? Because the weapons that they wanted have been brought in Nairobi, and last night they were there and we saw them. They were there. What do the ballistic officers want to go? There was no shooting in that home. And they are being told they want to go and check the homestead. I don't know whether the structure of the home has anything to do with guns, or whether the structure of the home can accommodate guns or not. Why do they want to go there? They don't even need to go there. And that is why they want 15 days, so that a ballistic officer can go and see the setup of the homestead. 15 days. So on the first day, he will go and see the gate. The second day, I don't know what he'll go and see. But and in case they ever bring any charge, and they find that they have found any other material or anything else, they'll come under Section 214. They'll amend the charge, if at all there'll be any charge. But I'm sure that this one is going to embarrass them. This one, they have already burnt their fingers, and they know it. Because, Your Honor, eventually, and you have done such many cases, in a homestead where you'll find 1,001 adults, including visitors, how will they pin this down on him? So what are they going to investigate? So they are trying to use your court, Your Honor, and this is what you need to avoid, because this is what they are trying to do. If you allow them to do this, you'll be descending into that arena, whereby now you'll be encouraging them and giving them life to keep on doing these things, and this is not good. It is not good at all. But for them, it is good for mileage. The DCI will be very happy, because why? Tulishika Governor. For him, the CV goes up.
Your Honor,
it goes with the DPP.
It has reached a point. It's a point. Unless my learned friend has evidence to place before this court.
This is evidence. The governor is evidence. They have nothing on him.
Your Honor,
this is evidence.
No. When he raises issues into the integrity of a constitutional office, Your Honor, it is important that my learned friend places evidence. Failure to that, Your Honor, I'm objecting to him uttering those words, because he will not give the Inspector General, the DPP, an opportunity to come, and that is why we are here. And they have an affidavit. I am praying that they stick to the affidavit, they stick to the evidence that they're presenting before this court and their authorities. Anything else, Your Honor, will turn amount to defamation or...
Your Honor,
and to me, he's either trying to intimidate the court or any other person.
The court cannot be intimidated.
No, those words are meant for that purpose, Your Honor. And I'm asking that he be stopped from pursuing that line.
Yes, yeah. Your Honor, let me withdraw, but at least they know now what is in my heart.
That he can go to the Inspector General and tell him personally while he's under arrest.
Your Honor, you give us bond terms. The accused person, the respondent, will not interfere with any witnesses. That one they have been able to show. If they want him, as and when they require him. which we have done before, even in Kisumu, in the murder trial, even in CID headquarters. When they wanted him, he attended. If they want him, he will attend. He will obey the terms and conditions that you give. And please, Your Honor, if at all you'll consider our request, don't ask for a passport because they have it. They took it in the other case. His home is known where it is. That is where they went and found him. He has a residence. He has a family who are depending on him, and they were there when he was being arrested. Even some of them are here today. He holds a public office which cannot allow him to do any interference of any kind. For him, it will be an embarrassment. In fact, Your Honor, let me stand here and tell you unashamedly, without any embarrassment, without any fear, without batting an eyelid, that give him free bond. He will come. That is the kind of person I can stand for. That is the kind of person we are standing for, because we know his integrity, we know what he can be able to do. He respects the law, he respects this court. And Your Honor, you are not being intimidated. And as long as there is no holding charge, Your Honor, you can only find in our favor. That is all I ask.
Response? Your Honor, if someone or the respondent herein is faced with multiple investigations, there is a high possibility of such a person.
May I object to that? I think the multiple investigations is a new issue.
He has talked about, no, Mr. Mbeta has talked about him having been arrested, and if he's called again, he will avail himself. That came out in Mr. Mbeta's submissions. So I respond to that by saying that where someone is confronted with multiple investigations, there's a high possibility of him interfering with the witnesses and the investigations. Public interest, yes. This and any other investigations or offense that involves an unlicensed firearm or ammunition is one of public interest. As there is a rise of firearms, that's unregistered firearms in the country, and the rise of the use of firearms in crime. That is part. Therefore, this is a public interest matter. Again, Your Honor, there is nothing like bullying. No evidence has been advanced by my colleague. And I submit, and I humbly submit, we have complied with Article 49. He was arrested on the 14th at the Hilton Hotel basement and arraigned within 24 hours. Data, where we need to do the data, analyze the data, receive the results from the experts. Your Honor, why we're asking for the 15 days, it is important that these investigations be conducted. Statements will be recorded. Further investigations will be recorded to confirm the investigations or the process of the investigations. Your Honor, possession has very many forms. It's not only the one where one is actually holding a firearm. There's actual and constructive possession, and the investigations are revolved around that. Again, Your Honor, in the respondent's affidavit under paragraph 6, they have confirmed that initially it was the Ethics and Anti-Corruption Commission that went to the residence. Inspector Philip Sang and the team from Special Crime Prevention Unit are now in conduct of these investigations, and therefore the need for them to go back to the homestead and carry out investigations as they are mandated under the Police Act. Your Honor, under Article 20, it provides that the Bill of Rights applies to all law and binds all state organs and all persons. Article 20 of the Constitution of Kenya 2010 provides that the Bill of Rights applies to all law and binds all state officials and all persons. The respondent is not an exception, even though he holds the capacity or holds the office of the Governor of Migori. Your Honor, Article 25 of the Constitution of Kenya provides for the laws that cannot be limited, even by statute. Article 49, that's the rights of an accused person, is not one of them. Article 25 provides for the rights that cannot be limited even by statute. Article 49 is not one of them. And therefore, Section 36A of the Constitution of Kenya is not unconstitutional and is binding. 36A, no, of the Criminal Procedure Code. Therefore, Your Honor, in the Michael Rotich's case, that's the first authority given by the respondent, again, the same can be distinguished in this matter. The applicant therein had not been informed of the investigations or the probable charges. The said ruling was delivered on the 21st of July 2017. The second authority, that is the Abdulaziz Mohammed, was delivered on the 9th of September 2016. For Michael Rotich was delivered on the 9th of September 2016. Sorry about that. Well, the Abdulaziz matter was delivered on the 21st of July 2017. And it is in this matter, Lady Justice Ngenye correctly distinguished the Michael Rotich's case. And as stated in her ruling, on page 5 and 9, she held that Article 49(1)(g) allows the detention of an arrested person without trial as long as he's first informed of the reasons for the continued detention. And this was not done in the Michael Rotich's case, but it has been done in this matter before this court. The last authority that they have given, that is the one of Gladys Wamboi Mwangi and 3 others. Again, on page 2, we distinguish this from the current matter before this court. Lady Justice Maureen Odero held that the applicant in that matter had been held for a period of 10 days and therefore held that that time was sufficient for the police to have made a decision one way or another. In this matter, Your Honor, we have just complied with Article 49 and availed him, and as guided by the Abdulaziz matter, we are seeking leave of this honorable court to continue detaining him for a period of 15 days. And again, that's not reasonable. Unreasonable, sorry. And sorry, I've done this. Paragraph 2 of our affidavit confirms that the said items were recovered from his residential house in Rabogi. They are talking of a guardhouse. That is the assertion. Our investigations are very clear where the said firearms were recovered. Your Honor, again, we are saying that we are asking for the 15 days to secure the evidence in form of statement recording and receiving of other experts' evidence. And the only way justice can be served in this matter, Your Honor, is for this court to enable us have that environment to record statements. Again, we have said we will not disclose at this point the witnesses, so as there may be no interference in terms of investigations and statement recording of the probable witnesses, noting that the investigation is at its early stage. And again, as stated, that the respondent is the governor of Migori, again, to avoid influence. Again, we cannot disclose whether the witnesses will be family members, his bodyguards. At this point, we cannot disclose. It could be anybody. And we're asking the court to just give us this opportunity to enable us secure in terms of statement recording. And again, my lady, in my introduction of this matter before court, I also referred to Article 49H. I referred to it and read it to the court, that we also hear pursuant to that. And we're asking the court to find that the reasons given in our affidavit are compelling reasons to enable this court not to release the accused person and give us the 15 days we have prayed for the continued detention. That is all, Your Honor.
The Migori police station, they can still detain him there.
You have no objection to that?
They can start taking the fingerprints.
Your Honor, I believe my learned friend needs a forum to go and express himself, and we'll do it outside. Yeah, we'll do it outside. Tell him to wait first. I mean with this, eh? Give me this. Please, can you just please let us start from
gari hiyo watu hapa jokuja ilikuwa walete gari
date ingine.
ilikuwa date ingine tu.
Maybe I'll just Yes, Your Honor.
Ulihukumiwa kwa shtaka la kuwa mtu bila kukusudia kulingana na sheria 202 kusoma na 205 kanuni ya adabu.
The facts that came out with the evidence here were that the deceased here
Maelezo ni kwamba marehemu hapa
started a fight with the accused.
alikuwa vita na wewe.
Then the accused retaliated with 2 blows that threw the deceased to the ground, causing him fatal injuries from which he died.
Kajibu kwa kupiga mangumi matatu ambayo ni maumsha chini akapata majeraha ndio kusababisha kifo chake.
The prosecution submitted after the conviction that the accused was a first offender.
Kwa mashtaka kwa toa maelezo kwamba baada ya kutenda wewe ili kosa la
Migori Obado.
Always remain a leader of choice. We are not after superimposed leaders.
Tumechoka na siasa ya dictatorship. We are tired. Tumechoka na mizigo.
Sio kila siku Migori Obado, Migori Obado. Migori ni county number 44, Mwanza na county number 1 mfike namba 44. Sio kila siku Migori Obado. News ni Migori Obado. Mnatubogwa. Hata anafurahi
Umegodi.